All right. Thank you, everybody, for coming. This is a program called Reining in Big Tech, Antitrust Law at a Crossroads. The program is sponsored by CLIck. For those of you who don't know what CLIck stands for, you can join me. You're in good company. But no, it actually stands for the Center for Creativity. Right. It's the Center for Law, Information, and Creativity. I got that right. I'm going to learn it eventually since I'm part of it. So thanks to CLIck for putting on this event. One of the reasons we wanted to do this event was because there's been a renewed interest, probably the reason why you're all here, in antitrust law. And many of you have probably seen these battles playing out with Facebook, Google, or Meta rather, Google, and other large companies. And the FTC has gotten much more aggressive since Lina Khan has taken the helm. And so we thought this would be a great time to enlist some of our Northeastern faculty expertise on antitrust and big tech. And so for that, we have three panelists who I'm going to introduce now. Starting farthest from me on the left is Professor Elettra Bietti. She's an assistant professor of law and computer science here at Northeastern School of Law and Corey School of Computer Science. She researches the regulation of digital technologies, data, and digital platform intermediaries. And she's published a lot of papers in a lot of places, what I always say. Gary Cooper, next up. He is a lecturer in law here at the law school. He teaches antitrust, the introduction to the law of contracts and transactional drafting. He's had a long legal career, starting in 1977 as a labor and employment lawyer, serving both the public and private sectors at a number of positions, including at the Boston office of the Federal Trade Commission, and worked in private practice until he retired recently, but he's still active here and teaching at Northeastern. And we have also next to me, Professor John Quokka. He's the Neil F. Finnegan Distinguished Professor of Economics. He teaches and conducts research in the areas of industrial organization, antitrust, and various regulatory economics. And he was most recently economic advisor to Lina Khan at the FTC. So I'm going to have each of our panelists say a word or two about the topic, and then we'll start a Q&A. So Elettra.
Thank you so much, David. It's exciting to be here and talk about antitrust. I think we decided to put on this event because students are increasingly interested in this topic, and all of us teach it or will teach it. And so we're hoping that you guys will learn something from this, and also it will be an opportunity for us to have a conversation among us. So I'm going to start and sort of frame the context or landscape for why we are currently talking so much about antitrust and big tech, why when you read newspapers, there is constant news about antitrust lawsuits against Google, Facebook, Amazon, and more. And so I think the starting point for me is the 1990s, when lawyers, policymakers started debating the regulation of the internet and started to think about what form law should take in the digital economy. And for a really long time, people imagined the internet as this highly decentralized, competitive space that was, that fostered individual initiative, freedom, innovation, that allowed people to engage with each other on a very equal footing. The internet was populated by small websites, blogs, bulletin boards, and it was very diverse, right? And so the attitude of a lot of lawyers and regulators was to try and kind of stay away from the internet and let players on the internet, private actors, do their innovative things online. What happened as a result of that sort of hands-off approach, which we see obviously in various areas of the law, right? So it's not just an antitrust question. There's the First Amendment and free speech laws, which contributed to kind of a hands-off approach to regulation with regard to these spaces that were very speech sensitive. Privacy law also was very hands-off. A lot of the ways that Americans tend to think about privacy is through a notice and consent, self-management approach. We could maybe also, I can answer questions about that if any of you is interested. And in antitrust, there also has been a very hands-off approach. And what's interesting perhaps is to kind of foreground a little bit more of the history of antitrust. So antitrust is a complex, significant body of law in America, in the US, which was born at the end of the 19th century, and which initially was aimed at fighting concentrations of commercial power. So the very term antitrust is fighting trusts, which were concentrations of power in railroads, in oil industries, and other industries that were key during that time, during the Second Industrial Revolution. And antitrust law then evolved over the course of the 20th century in significant ways. And scholars and policymakers these days talk a lot about a shift that happened around the 1970s, 1980s, which is what people call a neoclassical shift toward a more consumer welfare focused approach to antitrust law. The way we can understand that shift is that this body of law evolved from an initial focus, which was very much one that was concerned about the plurality of players on the market, the structure of these markets, how many competitors there might have been at the time, how to fight large oil barons, to in the 1980s an approach that was a lot more interested in efficiency and outputs. And so speaking of this in kind of, if we take Amazon as the example, we could see the problem as current or neoclassical antitrust scholars, policymakers want Amazon to be efficient, are very happy if Amazon charges very low prices to consumers. And the concern is not so much that Amazon, with that power that it's accumulating, might exclude possible new entrants in those markets, might have negative effects on innovation long term. The concern is to basically ensure that at this present moment in time, prices are as low as possible and the size of the overall economic pie is enlarged, right? And so this focus on the size of the economic pie has somehow obscured alternative interests that we all might have as democratic citizens in ensuring that the economy is also diverse, that some of the benefits of the economy are fairly redistributed. And in other words, right, maybe by allowing Amazon to grow, we're favoring the interest of shareholders of Amazon, we're favoring the interest of, say, Jeff Bezos, we're not necessarily, or perhaps even of many consumers, but we're not necessarily favoring the interests of other commercial players, other actors who might develop better products that might compete with the products that are currently available on Amazon, right? So that's the landscape that antitrust law has been in for a while now. And so the second historical shift that is of relevance these days is a shift that I would say started in the 2020s, so very recently. And perhaps one of the initiators of this trend was current chair of the FTC, Lina Khan, who was a law student at Yale and wrote a student note in 2017 called Amazon's Antitrust Paradox, which really started a conversation around how to shift antitrust law's purposes from this prevalent focus on increasing the size of the pie to a greater focus on market structure and how many players are on the market and how to ensure that new entrants, startups, innovative players can compete with current incumbents and big tech, right? I don't know how much time I have, but I can offer a sort of overview of how this plays out in the tech space. So what happened is many of you will have heard of the important Microsoft case, which was a significant case that imposed unbundling remedies on Microsoft. So Microsoft had to allow various device manufacturers to unbundle themselves from Microsoft's Windows and Microsoft's Internet Explorer services, and instead decide to use different services, right? Other competitors. So that case was really important. But what's interesting when you look at the tech landscape is because of this kind of bias in favor of deregulation, hands-off, and sort of libertarianism in digital markets, for a long time, that Microsoft case remained as a very much an outlier. And a lot of what happened in the antitrust world were failed cases against big tech. So there's an important merger between Google and DoubleClick, which was looked at, investigated by the FTC in 2007. And the FTC basically concluded that even though that merger raised significant privacy considerations because it allowed a large ad tech player to merge with a large search engine and might actually lead to an internet that would be primarily controlled by one actor, Google, that was something that, the FTC was very much aware of, but they couldn't frame the problem of privacy and ad tech in competition law terms, in antitrust law terms. And so they had to allow the merger to take place, right? So that's one example. There's been an investigation of Google around the 2010s by, again, the FTC and state attorney generals, who again looked at Google search, thought, Google is a dominant player on search. Google can favor results that are beneficial to itself and not necessarily allow, other players to either compete on search or to present other forms of ranking. They looked at this case, but antitrust law didn't necessarily help the FTC at that time. And a lot of advocates basically succeeded in arguing that Google was a very strong competitor, that they were very innovative. And so ultimately, we should look at that problem as Google is just better at competing and not as a problem of there's an incumbent that's using their dominance on a market to stave off competition and exclude potential entrants from this market. So then zoom on or zoom in or jump to today. Obviously, we're seeing a very different landscape today with a new FTC with Lina Khan as the chair. There's Jonathan Cantor, who's leading the antitrust division at the Department of Justice. And the agenda of many of these policymakers who are setting the rules right now is a progressive agenda that is precisely trying to move from increasing the size of the pie to trying to redistribute how or rethink how we're sharing the pie. And so we're seeing a lot of really interesting cases. We're also seeing some legislation proposed in Congress, which will not succeed, unfortunately. And at the same time, we're seeing a lot of interesting regulatory experiments on the other side of the Atlantic in Europe with the Digital Markets Act. And the final thing I'll say is that as part of this evolution, one thing that I see as quite important is an increased focus on the infrastructural and vertical power of online tech players. So we're no longer in a landscape where antitrust regulators look at horizontal markets, and we can talk more about what horizontal markets might, or horizontal competition is about. But instead, regulators are thinking about how, taking the example of Google, how Google's presence on a variety of different market segments, right? Search, operating systems, maps, email, and you name it, might give it advantages on other markets. And the AI space is particularly interesting here because, of course, if Google possesses a lot of data, they have an advantage in things like LLMs, generative AI, for example, right? Or Amazon has and Microsoft have an advantage because they control cloud services and so have a lot of computing capacity that gives them an advantage on these new markets. And so regulators are really worried that the existing incumbents, big tech, will have power over the future innovative markets that could otherwise be competed on. So that's where I'll leave it for now. And yes.
Thank you very much. So I guess my job here is to talk like a lawyer for a little while about what the principles are. And for those of you, and I see a few of you who know me, typically I use slides. I'm not using slides today. I'll spare you that. But I will use slides myself to sort of guide myself through this. When I thought about this program, I thought about the context is reining in high tech. So what does that really mean? That means what lawsuits and what policy changes have we made toward changing the nature of the landscape in high tech? And that really had me thinking about, well, what cases really have been brought and what cases are pending? And so they're really, if we think about the role that the government plays in antitrust, there are two actors, the Federal Trade Commission and the Department of Justice. They each have jurisdiction. The Federal Trade Commission's jurisdiction is limited in the statute that grants jurisdiction. It is an enforcer of the antitrust laws, but not a criminal enforcer of the antitrust laws. The Department of Justice doesn't have a specialized statute like the Federal Trade Commission Act to rely upon. It relies upon the general statutes. I'll talk about those in a moment, but it has criminal authority. And they overlap often in their jurisdiction. So I thought, well, the key thing here is to get a sense about what is the government actually doing about this in the sense of as an enforcer of the antitrust laws. And there are really four cases that come to mind that are now pending that we should be aware of as we think about this. There are two cases, well, I think I have right in front of me here. There was a case brought by the Department of Justice against Google in 2020, October. It was recently tried. So for those of you, I'm not in a position, I'm certainly not going to spend time talking about each of these cases in turn, other than to say that these are the four cases you should be looking at or thinking about. That case was tried. It's now pending judgment. I think last I checked, the final arguments are coming up. We know, thinking back to last October, we probably saw news reports of Google's president going in to testify and various people coming in and out of the courtroom during that period. That's all now pending. That case was directed towards search. So what does that mean? It really was around this idea that when you turn on your phone, guess what? There's a default there. That's when you buy your phone, it defaults to a particular search engine. More often than not, the reason why it defaults to the engine that it does is because somebody paid the maker of the phone to do that. And it came out in this trial that Google paid tremendous amounts of money or was paid tremendous amounts of money in turn, depending upon what we're talking about. But we're talking about in the search business, this idea that by commanding the search market, that therefore you can somehow have market power over a general search. How's that important to us? It's important in the sense that the more search is conducted, I suppose you could say the Google environment there gets more data, develops a more robust system that gives it scale over any competitor. That's why we see that Bing, the Microsoft product, is 6% of all searches. How's that possible? Microsoft is so powerful. I think in part it might be, I'm not an economist, but I understand behavioral economists have said that it's like when you start a job and you fill out the paperwork and they say, well, the default is you're not in a retirement plan or you're not doing things. Studies have shown that if that's the default, many people don't actually join these programs. And now I think there's some effort underway to make the default option that you are part of it. Well, if we think about your phone, if the default is on most phones, the Google search, well, we saw that people are, behaviorally speaking, not prepared to make the change unless there's some rational reason why they should, and often people don't have a reason to change. And so what happens is over time, Google developed the scale of customers. And a part of it was just by people people's inaction. So I don't want to stray too far, but that's fundamentally what's involved in the search case is this idea, what advantages does Google get from having the default position? What payments did it make? And whether or not it engaged in anti-competitive activities in order to maintain that status as the search leader. The second case we should be thinking about, also filed in 2020, was an FTC action against Facebook. Facebook had, there's a long tortured history, but for those who are still with me on this, the market there was personal social networking services in that case. The unlawful acts, as we'll see, I'll explain how unlawful acts come into play in this kind of analysis. The unlawful acts related to acquisitions. We may remember that Instagram was acquired by Facebook some time ago, and so was WhatsApp. And the rationale for this case is that these were activities, acquisitions that were designed to maintain a monopoly position or to, or as an effort to monopolize the market for what do they describe as personal social networking services. This third case we should be thinking about, and the fourth case as well, were brought in 2023. The first of these was brought by the Department of Justice against Google in the so-called ad tech market. Now, I'm not going to describe much about what are the unlawful practices allegedly in that case, other than to say that the complaint itself, the complaint itself takes 5 or 6 pages of double-spaced text to explain how these ad tech services and ad tech platforms operate. Matter of fact, the best way maybe to understand them is to look at the photos that accompany or the diagrams that accompany the actual complaint, because then you can see that what we're talking about here are cases of platforms. So in the first of these, the Department of Justice action against Google, Google operates a platform. The platform, of course, is, among other things, its actual search results. You notice when you come up with search results, you get advertisements as well. People pay, advertisers pay to be positioned there. And so what this case is all about is whether or not the Google in the ad tech market has structured the process of the ad tech market, which involves also auctions, online auctions, in order to determine prices and placement of ads. By the way, all of these auctions take place instantaneously while you're awaiting the search results when you're searching. And companies pay lots of money to have their results pop up. But Google, being in the middle, is now effectively accused of preferring itself when it comes to how payments are structured. And then the advertisers are basically saying, we're not being compensated as much as we should be, or we're paying more. The platforms are saying we're not being compensated as much as we should be, as much as Google's platform is. And the advertisers are saying, basically, we're overpaying in part. I'll let all of you sort it out, but other than to say that this is clearly an important aspect of commerce. We're talking about the advertisement business, digital advertising business. I mean, there used to be a climate, I think, in New York where there were a lot of small digital advertising firms. They've largely gone out of business or consolidated, in part because of the nature of ad tech on the internet when it comes to advertising. The fourth case I want to mention very quickly is FTC versus Amazon, a case filed, I'm sure there'll be a lot of discussion about this, but in 2023, it's now subject to a motion to dismiss. So a motion to dismiss has been filed and is now pending. It was filed in federal court in the state of Washington. So it'll be interesting to see, I mean, Amazon is headquartered there, so it's no surprise they might choose there. But on the other hand, it'll be interesting to see litigation emanating from a circuit other than the DC circuit or maybe the Fifth Circuit, where lots of actions end up, it seems. But what's the focus in that case? The focus in that case is that Amazon is self-preferencing perhaps its own products, using techniques associated with how firms are able to get placement on and show up in the search results when you search on Amazon for a product, whether there's a self-preferencing going on. There are many other allegations associated with this. It's too short a period for me to go into greater detail, other than to say that the interesting thing for me in this instance is the FTC is making a standalone claim that is not based upon the Sherman Act or the Clayton Act, which are the federal statutes that would give original jurisdiction in the federal courts. The standalone claims are being made on the basis of Section 5 of the FTC Act. And in my experience, I have not seen standalone claims of that nature brought in the past. So I think we'll have some surprises maybe when the motion to dismiss is decided sometime, perhaps later next month. I think the reply for the might be due on the 24th of this month. So we're a month or so away from the motion to dismiss being decided there. If I have a moment, what I want to do is we've talked about what are these cases about, and I've explained to some degree what the nature of these cases are. I just want to take a minute or two to say that when we think about the antitrust laws of the United States, fundamentally, we're talking about three statutes. We're talking about the Sherman Act, enacted in 1890. Now, we can all imagine how possibly could a statute enacted in 1890 be relevant and be useful in antitrust in the 21st century. It's because it's been drafted so broadly. I'll talk about that in a moment. The second statute that we should be aware of is the Clayton Act. Now, the Clayton Act was enacted in 1914. Again, we might ask, what relevance and possible help could that statute be? Again, but it's broadly stated. I'll discuss that in a moment. Finally, the third act we should be thinking about is the Federal Trade Commission Act itself. Again, enacted in 1914. So if you'll bear with me, I want to take a moment just briefly to review these three statutes, just so you have in mind what the legal tests really are. The first statute, the Sherman Act, has two sections that really are significant, Section 1 and Section 2. Section 1, we're probably not going to talk about much here today. That's the section that says that every contract, combination, or conspiracy in restraint of trade is declared to be illegal. That's the statute. Now, again, a statute so broad is really not very instructive about how the statute is intended to be applied. But nonetheless, courts beginning last century interpreted it to that provision to prohibit unreasonable restraints of trade. But by definition, they have to be accomplished by more than one entity. There has to be a contract, a combination, or a conspiracy. You can't conspire with yourself. You can't conspire with your wholly owned subsidiary, but you can conspire with a competitor or some other entity. And if you engage in that kind of contract, combination, or conspiracy, and the result is that it restrains trade unreasonably, with what now is the test, well, in that instance, that will be a restraint of trade in violation of that statute. The one we're going to think about most in this context, however, is Sherman Act Section 2. And that's because we're dealing here with single firm conduct. There might be implications in some of the complaints we read in these cases of conduct engaged in by these firms in combination with other firms, and those will be viewed as potentially violations of Sherman Act Section 1. But most of the conduct relates to decisions made, business operations, business methods by these firms. And the question in this context is whether or not they violate the monopolization statute. So what does the monopolization statute says? It says simply in simplest terms, it says every person who shall monopolize or attempt to monopolize or combine or conspire to monopolize with any other person or persons. So again, the conspiracy could be with any other person, but in the first instance is if you as a person shall monopolize. So what are we concerned about monopolization of? Well, it's stated so broadly, any part of the trade or commerce among the several states or with foreign nations. So that broad proscription of that kind of conduct remains the guiding principle for how antitrust laws are enforced. But as you can probably, finally, before I go on, two other statutes I think I want to bring to your attention very quickly, and then I'll move on to let someone else talk. The next of these is the Clayton Act, Section 7. Now, there are other provisions of the Clayton Act that you'll learn in antitrust if you were to study it, but the one I want to focus in for a moment is Section 7 of the Clayton Act. It was enacted, as I said, in 1914. It was amended significantly in 1950. What's the nature of this? It bars acquisitions, initially just of stock, but later of assets as well, of one firm by another, where a consequence would be a substantial lessening of competition in any line of commerce in any section of the country. So again, it's stated so broadly as a proscription that it virtually any, any transaction would run afoul of it, provided you can prove the elements. And the element being the need to prove that the acquisition effect of it may be to substantially lessen competition. Finally, I want to bring to your attention the FTC Act, Section 5. Now, we probably all understand that the FTC Act created the FTC as an administrative agency. It empowered it to enforce the statute that was in its creation. There are two elements to the mission of the Federal Trade Commission. One is a consumer protection mission that's designed to prohibit unlawful or deceptive trade practices. The second mission of the Federal Trade Commission is to prevent unfair methods of competition. So what does that mean? Well, the statute says simply, and provides in pertinent part, unfair methods of competition in or affecting commerce are hereby declared unlawful. That's the statute. So now that I've presented all these statutes to you in their bare bones, what's the implication of that? The implication of that is that the courts and litigators develop the law under these statutes. We might contrast that with what appears to be happening in Europe right now, where they have a Digital Markets Act. I'm not by any stretch familiar with the particulars of it. I'm hoping somebody else might be, but if not, I think the point that can be made from this is apparently that's in a legislative enactment that contains a lot of findings about what's important and what's anti-competitive in these marketplaces involving digital platforms, or excuse me, any digital market services, I suppose. And the answer is you've got legislative direction. We don't really have that here. We develop through case law. So I think I've said my part. I'm happy to pass it on.
Thank you, Gary and David. And let me give a special thanks to Elettra for organizing this, and Jennifer and the law school staff for putting this together. It's a pleasure to be here and have a chance to talk about what's going on in antitrust economics and the law. Elettra and I were talking a few months ago when an article had appeared in Politico describing Lena Khan's visit to Arizona State University Law School, where she was greeted as an antitrust rock star. Now, I've been doing antitrust for a long time, but those are two phrases that don't usually appear in the same sentence. And so it really described the way that she's been received by law school audiences and by some, at least, economists, including myself, as bringing a new perspective, set of priorities, and an enormous amount of energy to agencies that had been very used to looking at issues in a very traditional way. So what I want to do is to talk a little bit about my role there. Soon after I had known Lena for some few years, and soon after she was appointed as chair of the FTC, she contacted me and asked if I would be interested and willing to serve as her economic advisor, and I quickly said yes. And so I went on leave here from Northeastern for about a year and a half. And Lena had asked me primarily to work on the revision of the merger guidelines. So the merger guidelines are a document issued jointly by the FTC and DOJ, Justice Department Antitrust Division, setting out how the agencies examine mergers. And they are quite detailed. They are turgid reading, but they are the document that explains to the court and also to companies and their counsel exactly how the agencies will evaluate standards, processes, and the like. These had not been revised since 2010, and they are typically revised every 10 or 15 years. One of the focuses, and there are several things demanding revision this time through, including some things we're probably not going to have time to talk about today, but quite important. But one of the things certainly that drew Lena Khan's attention, and that too of Jonathan Cantor, who's head of the Antitrust Division at Justice, was the tech sector. So um, the tech sector, is familiar, as Gary had pointed out, to all of us. It's so deeply ingrained in our daily lives that it's easy to forget exactly how revolutionary some of the astonishingly brilliant ideas that the core innovations of Google and Amazon and Apple and Microsoft too have brought to us. We would be a much poorer society and economy if it wasn't for the Amazon platform, for e-commerce, for Google search, kind of astonishingly miraculous invention, and for the iPhone and other things that have come out of Apple. So, there's no doubt that these are enormously important innovations in the economy. And for the longest time, the regulators, the antitrust enforcers, and Congress too was in awe of these. 5 or 6 years ago, when I spent a little bit of time in talking to folks on the Hill, one response I got was that Google owns this town. There was really no tolerance of criticism for what Google was doing at that time. And whenever the representatives, executives of the tech companies came and testified before Congress, Congress more or less fawned over them. And the agencies, as I think both Gary and Electra have pointed out, did investigate some of the activities of these companies, but took a pass on all of them. So over the past 20 years, the 5 major US tech companies have acquired 900 companies, 900. And, I've looked at them. Various people have looked at them, try to categorize them, think about who they are, what they're doing, and why the major companies have acquired them. I mean, to be clear, most of them are benign, but not all of them. And when the agencies have looked at them until recently, they've basically done nothing. Up until about 3 years ago, I think it was safe to say that not a single one of them, those 900, had really been through a serious investigation at either the Justice Department or the FTC. So Europe has been a little bit ahead of us on this front. They've attempted to deal with some of the major tech companies, have made efforts to deal with some of their practices and a couple of the mergers. So they're a few years ahead of us in several respects. But they too have, until recently, not gained a lot of traction against these companies. So in the 900 companies that were acquired, and they're widely distributed, 100 here, 250 there. It's a lot of companies to be acquired, have built out the tech platforms into what are oftentimes now called in the popular press ecosystems, right? So these are tightly integrated networks of businesses that dovetail with each other, reinforce each other, and allow the tech companies to sort of monetize their platforms in ways that you can't always sell the platform. I mean, Google sells search to advertisers, but it's really an advertising company. That's where it makes its money. It doesn't sell search to you and me. We don't pay for doing a Google search. The monetization comes through some other avenue, and that's true of a lot of these companies. Facebook makes zip in the way of revenues directly. 98% of its revenues are from advertising. These are best thought of as advertising companies, where we are drawn into the ecosystems through a lot of the, quote, free services that they provide. So what they've done is to build out these systems as ways both of monetizing their core platform more fully, but also many of the acquisitions that they've made have, certainly had the effect and probably the intent to preclude competitors from getting into adjacent businesses. So maybe not directly into search, but to prevent others from getting any piece of the search business or to impede their monetization process. So, if you think about Google, Google acquired Android, by the way. It did not construct or build or write the software for the operating system. But Google has linked its ubiquitous Android system, ubiquitous except for Apple users, to Google search. So if a smartphone manufacturer wants to use Android, a condition is to pre-install, typically on a default and exclusive basis, Google search. If merchants want to use Amazon Marketplace, and increasingly, if you want an audience, if you want to reach customers, businesses feel compelled to be on Amazon. But if you do so, you have to use their logistics service, their distribution service, at least until quite recently. Apple, everybody's favorite, has made its watch work better with the iPhone. So if you have an iPhone and want someone else's smartwatch, you will find that it's a bumpier, less seamless operation than buying the Apple Watch. So the key thing here to recognize is that none of the examples I gave, which are 3 amongst a myriad, are technologically necessary. You know, it's possible to split off logistics from Amazon's e-commerce platform. The bright idea is e-commerce. Bright idea is not distribution necessarily. Similarly with Android, the bright idea is the operating system, but you know, to link it inextricably to search is to do a couple things, including deny alternatives onto certain platforms. So none of these are technologically necessary. Some are valued by consumers. There's no doubt about that as well. Consumers like seamless integration of services and platforms, and we all do. On the other hand, these are not the only reasons that the platforms want integration at this level. To repeat, they wanted to prevent the emergence of significant competition, and they want to monetize their core business. So why do they get away with this? So they get away with this because of their dominance. They have market power in their core business, so they can condition access to that core business, like, you know, Google search, on users accepting other services, or on Android, on Google, on customers accepting the necessity of pre-installing Google search if you want Android. And they can credibly make that all or nothing offer to other smartphone users only because it is a dominant search. And so a small company couldn't do that, could not credibly say, I'll only give you this if you take that, because people will say, you know, I got lots of alternatives for this core function that you're trying to foist off on me. They can simply say, forget about it and find alternatives. But once you're big enough to credibly make that all or nothing offer, and that's what the core platforms are, then other businesses have a hard time escaping the ecosystem. So occasionally some company tries that. Gary has mentioned the Google search trial that the Justice Department has brought. The trial happened in Washington over I think it was October, November of last year. Fascinating stuff. But it also, in the process of trial testimony and the revelation of documents, recounted some episodes that were kind of interesting in explaining how it is not just small companies, but sometimes large companies get bullied against each other. So the example here is that Apple and Google. So you might think that neither of these companies are in a position to foist one of these decisions off on the other. So Apple and Google go way back because Google search was the default on Mac computers. But, you know, once Apple came out with the iPhone, it decided it didn't necessarily want Google search to be on the default search engine on the iPhone. Evidence shows that it thought about buying Bing and using that just so it could get out from the Google search. It didn't do that. Started to write its own search engine called Spotlight, which was a very limited, but had the potential to expand. And Google looked at this and got alarmed, you know, that it was going to lose its presence on Apple phones, on iPhones. And so documents from the trial indicated that Google thought of this as a serious threat. There's one document revelation in these trials. You know, it's like, it's fascinating stuff because you kind of see the way executives think and the strategies that they employ and the way that they contest with each other about various important issues. So what happened in this case is that, the Google executives exchange emails and other documents indicating their alarm over this prospect, and Google counterattacked against Apple. I tried to get iPhone users to install Chrome instead of Safari, to no avail. It actually tried to get the EU to attack Apple's ecosystem, which would only have benefited Google's preservation of its own. That didn't work either. And so ultimately what Google did was to pay Apple. It basically paid Apple to be the exclusive default search engine, Google search on iPhones. So, and this is what Gary mentioned. So, the result of the payment was that Apple stood down, no longer pursued its alternative search engine strategies. And Google got to be the exclusive search engine on iPhones, which it desperately wanted. How desperately? $18 billion. So trial testimony documents indicated that Google paid Apple $18 billion to stop its efforts to find an alternative search engine and to have Google search pre-installed on iPhones. So, like I say, Google was desperate to avoid any alternative being presented to iPhone users. Before anyone concludes that Apple's a good guy in this story, because all of you have iPhones, I'm the only one with Android. I do this with my students all the time. I've got an Android, yes, so be it. Everyone else has got an iPhone, and everyone loves Apple. But Apple has bullied some of its own users. It has extracted 30% fees for app developers just for installation in the App Store. I mean, this is just for access. There's no services being performed there. It doesn't, until recently, hasn't allowed anything other than Apple Pay to be used for payments on the store as well. So these are under attack now too as unnecessary parts of the ecosystem. They're not the bright idea. They don't have any particularly bright idea in these functions. They're simply using them to prevent anyone else from encroaching on their core turf. So these are the issues before the agency. No one is trying to, as I said, no one is trying to take down Google. What the agencies are trying to do is to keep Google from taking down its competitors. So how should we think about these from an economic point of view? So this is an interesting case. This is where modern industrial organization economics, and one or two of my students are here, has much to contribute because as Electra pointed out, 20, 30, 50 years ago, the neoclassical Chicago school convinced a lot of people that efficiencies drove the business and we shouldn't tamper with these things. Well, economics has come a long way from that. And I've never subscribed to the Chicago school. And now the agencies are in the hands of people who have broader lenses through which they view these practices. And there's also an enormous amount of sound economics being used to explain how it is that some of these practices can be anti-competitive. A professional colleague and friend of mine, Mike Winston, who's at MIT, was the testifying expert for the Justice Department in the Google search trial. And he's written several breakthrough articles on how it is we might think about tying and bundling of these services and exclusivity. And so under Lena Khan and Jonathan Cantor, this is where the agencies are being taken. They're, looking at some of these practices in different ways. How should we think about pre-installation and exclusivity? Let's see, these are good questions. Let me give you one brief answer, just only part of the answer. I can refer you to some impenetrable economic articles if you want to get the rest of it. So is there anything wrong with Google paying Apple for installation of Google search on the iPhone? Isn't that just like advertising or promotion? Pay to, present this alternative before iPhone users. The economic answer, of course it's okay to pay. It's okay to pay to be installed, to present yourself to potential users. Where it crosses the line is if you're paid to be the exclusive one, because then you're paying for that host not to offer your users any alternative. That's what that's what $18 billion gets Google. It gets to be exclusively the search engine. Now, yeah, you can work around it and do some other things, but it's worth $18 billion. They paid for something and they knew full well what they were getting. So it's the exclusivity piece of it that really represents the target of a lot of these suits, not all of them. I recently counted 17 or 18 suits against the major tech companies, and there are a variety of them. Some of them are against acquisitions, many of them are against these kind of exclusivity arrangements. Some raise issues about self-preferencing, like Gary mentioned. So there's a myriad of ways that these are now being scrutinized. But just to leave you with that thought, it is the exclusivity piece of it that is the most problematic, that raises the most serious competitive issues. So in 2 years, or 3 years now, perhaps, that Lena Khan's been there and Jonathan Cantor, the courts have started to accept some of the novel theories and initiatives that the agencies have brought before them. They lose some of them, but they gain some ground as well. The Meta Within case, the court agreed with the principle that eliminating a potential competitor could be anti-competitive. They disagreed on the facts, but they agreed with the principle. This may seem like a small deal, but it's a hugely important deal for the agencies to bring those sorts of cases. The FTC has won a vertical merger case, which has not really been successfully brought, maybe with one minor exception, in 20 or 30 years. Just recently, within the past week or two, it's refused to accept or challenge the Kroger-Albertson supermarket deal, the sort of thing that in the past had skated pretty much through the agencies. So it's a new day. I was excited to be there. It's an opportunity for economists to bring new learning and their expertise to bring to bear on these sort of traditional questions, because we're confronting new issues. And it's a terrific place for lawyers to start their careers. You're surrounded by unbelievably smart and dedicated people who are bringing fresh ideas, and at the leadership level, interested in new ideas, new ways of thinking about, new ways of challenging, new ways of thinking about some traditional things. So yeah, it is an exciting time. It was for me. Maybe it will be for you. I'll be happy to talk to anybody, by the way, later on at any time about opportunities at the FTC. Thank you.
All right. I have a number of questions I want to ask, but before I do that, I just want to kind of give a recap. So, we heard first from Alletra. She gave us a broad overview of historically how antitrust started and how it developed and where we are today. Then Gary told us a bit about the legal principles behind the antitrust law, gave us the 3 statutes and some cases. And then John provided some more context, giving us a view of what economics adds to antitrust. So I want to actually start by asking a question back to John about what I just said, which is, can you say more for people in the room about the role of economics as a social science and how it interacts with the legal doctrine? Because I think antitrust is one area where economics is really important, and it's actually the fundamental foundation of the law itself. So how does your work as an economist help Lena Khan pursue her claims in the court of law?
So every case has really 2 important components, 2 necessary important components. One, of course, is to present the law and to present the case law in a way that sets up the factual arguments. But economists then play a crucial role in most of these cases by bringing empirical evidence, sometimes some theory, and explaining the relevance of the theory and the empirical evidence to the facts in the case before the court. Because every case is unique. I've done testifying and consulting and other things too. Every case is unique and it has different properties from everything else. And so there is inevitably a debate between high-powered economists on both sides of the issues. The Google search case, I mentioned Mike Winston for the government. It had a couple of my friends on the other side testifying for Google. These are very entertaining debates on these sort of issues. So if Mike Winston argued exclusivity, the other side said, well, the evidence is that Google search is just a better product, and consumers want it. And when they're given a choice, they still take it. So there's a back and forth on that question, but these are the kind of factual issues that tend to be debated. So a lot of trial issues are debates between economists, of course, on the facts relevant to the legal theories. So within the agency, the Justice Department and the FTC, this is in the weeds, and so I won't spend any time on this, but the Justice Department and the FTC are structured somewhat differently, and the role of economists are somewhat different in the two agencies. But no case gets out of the agency without it passing muster with the economists, because it's a non-starter in court if it doesn't have economic support. That said, there's a lot of different economists around. You're talking to one that's pretty widely known to be on the more progressive side of the ledger, which is why Lena Kahn called me up. But you'll have no trouble finding counter arguments from other folks as well. But this is a necessary ingredient to bringing a case that will have any traction in court. So the agency, the chief economist now, not the chief economist, but the head of the Bureau of Economics at the FTC is Aviv Nevo, who's I helped hire him, widely respected, brilliant industrial organization economist. And, this is the sort of caliber of people that are now there. The same at the Justice Department, Antitrust Division. So lawyers and economists work in tandem within the agency. I once worked on a case where the chief lawyer that I was working with said, John says, tell me what the economics is, and I'll massage it into the legal case. Just tell me what the economic story is here, because that's the one I have to sell. And I'll bring it into a legal format where I can convey it to the court.
I mean, I just for the sake of debate, I think there are a lot of issues at the moment around the relevance of expertise in antitrust, or what kind of expertise should be kind of, looped into the investigation part and in the court part of antitrust cases. And for example, I think when we're talking about technology markets, there are other forms of expertise that are very relevant, right? Like technological expertise. So computer scientists are on high demand right now at agencies like the FTC, because these agencies really lack sometimes, there's lots of lawyers and economists, but there are not many people who understand cryptography and kind of data flows and how to empirically assess those technological possibilities and what tech companies actually do in practice on the ground, right? And so how can you investigate those companies if you don't understand what they're doing? And so you actually need all sorts of different expertise. I also wanted to add one thing, which is that I believe part of what's going on since the 2020s, since 2020 pretty much, and since Lena Kahn arrived and Jonathan Cantor arrived at their current positions, is that the move towards what is often called, you will perhaps have heard of, neo-Brandeisian antitrust, neo-Brandeisianism, is a move that perhaps tries to kind of recalibrate the importance of economic expertise, and that seeks to foreground other methodologies like history, like statutory interpretation, potentially like, pull from fields like sociology or political science and try to figure out, what are the impacts of antitrust law on inequality on the ground? What are the impacts on consumers? If the guiding principle is consumer welfare, should we rely on how economists define consumer welfare, which is kind of the point where supply and the demand curve meet, and perhaps John can say more about that. But instead, perhaps of focusing on those theories for interpreting what welfare increases mean and what it means to increase the size of the pie, perhaps we should look at effects on the ground and how people are experiencing those laws and the impacts of those laws, or how to quantify and empirically assess the welfare effects of some of these decisions, right? And so I think that there's a shift within economics, but there's also a dialogue that's being created between different disciplines that are empirically minded, but that are perhaps have kind of different tools to offer to the question of how do we deploy antitrust law and how do we do it in ways that serve society.
All right, I want to shift from economics to law a little bit. So Gary, you talked about the three statutes and the various sections within each statute that are used in antitrust law. And roughly speaking, we have price fixing, and then we have mergers and acquisitions, and then we have just other bad stuff that we don't like. And so I wonder if you could say a bit about how these three operate in maybe one or two of the cases you talked about, which is the predominant tool that the government's using, if there is one, or if they're all kind of used equally.
So I think the thing to keep in mind is, as I said earlier, we're talking about single firm conduct primarily in these cases. That is, we're looking at what can these firms do on their own without cooperation from anybody else in the marketplace that is anti-competitive, that results in a lessening of competition in the market in which they're operating. And so if that's our focus, it makes sense then to think about, well, what would be required in a monopolization case? What are the steps? What do you have to really show? Well, the first thing you have to show is that the firm that you're looking at actually is a monopolist. And that may be seemingly easy because after all, we all know these firms are very big and powerful, but to prove they're a monopolist, we have to look at the line of commerce in which we're really focused. Because some of these firms have more than one, obviously, business operation. So you have to define a market. So you have to show monopolization by the firm in a relevant market. So how would we determine that there's monopolization going on? Well, we can ask ourselves, did they do something improper, or did they engage in some kind of non-typical business behavior, let's say, that allowed them to get their position of dominance in their marketplace? If that's true, then we're talking about a monopolization case. But we also can look at monopoly from a different perspective. We know the firm's already powerful, but are they now doing things to maintain their monopoly improperly? And that means taking steps to exclude rivals typically. If we think about this whole scenario of having as a default on your phone the Google search, they got that position by acting with someone else in an effort to exclude a rival from having a position in on that same phone. They engaged in an exclusionary practice. How were they able to accomplish it? Well, they paid a lot of money, but part of it is they had a lot to offer to begin with. You already have to have a dominance of some kind before another party is going to want to enter into an exclusive arrangement with you. Because otherwise, they're giving up the opportunity to deal with someone else. It's only when it's in their best economic interest. And how can it be in their best economic interest? Well, in most instances, because they're dealing with a powerful firm that's going to deliver to them, or alternatively, they have no alternative because that's the firm they need to deal with. So when we think about the practices of the firm, we're looking at what behavior did they engage in to become dominant or to maintain their dominance. And I'm going to end on this. That automatically sets us up into an economic type analysis. How so? Because we're asking ourselves, are they engaged in conduct that we can term anti-competitive? Who makes the judgment on that? Well, we have to have an understanding of how markets operate to reach that judgment, that activity is anti-competitive. It's not consistent with free markets and how free markets operate. We need economists. That's why throughout this discussion, there's been this presentation to you that this is the marriage of attorneys and economists. This is the field in which they have to operate together because the first thing, as I said, is you have to show the conduct engages anti-competitive. That requires an economic analysis. Conversely, the other side is trying to show that what they're doing is pro-competitive, meaning it benefits consumers. If we look at consumers as being the ultimate beneficiaries under consumer welfare kind of standard. So what I want to point out to you is that ingrained, built into the legal tests are economic judgments that need to be made. And
But I just add one thing, and that is that Gary's of course quite right, and Electra as well. This is the way cases are built and brought within the agencies. But in the US, these go to non-expert courts. The judiciary, the federal district court population of several hundred individuals is not a population that's schooled in economics of any flavor. And so, the average federal district court judge sees an antitrust case once every 5 or 10 years, somebody calculated. I mean, in some districts more often than others, but they're unfamiliar. These are not like the run-of-the-mill cases that they get. And so they're non-expert, and increasingly they're conservative. They've been appointed by conservative administrations. And so the hurdles, evidentiary hurdles that they impose on the government as a plaintiff in these cases can sometimes be pretty daunting, excessively high, at least in my view and that of others. So the European system is different. In the EU and Brussels, they have a more administrative system where judgments are made with much more limited opportunities to appeal to the outside courts. So judgments are made by expert agencies. And it's kind of an interesting contrast. There are arguments to be made on both sides, but it's often the case in fashioning cases in the US. One has to keep a very close eye on how the argument will eventually play out ultimately before a court, because that is where the story has to be sold. That's the ultimate constituent.
I think it's a really good point. I want to ask Electra one question, and then I want to make sure we have time for questions from students and others present. Electra is the only European on the panel, and we've been talking primarily, only exclusively about US law. You mentioned at the beginning about the Digital Markets Act and how EU, John just mentioned something also about how the agencies and regulatory bodies deal with this problem differently. I wonder if you could say a bit about the differences between how these debates and court battles are playing out in the US versus Europe, and whether you see those differences as meaningful and either positive or negative.
Yes, I'll try to keep this brief because also I want to hear from everybody. But so my perspective on this is that Europe and the US are not as different as people tend to describe them. There is a kind of difference in timeline. So if you look at what happened in Europe at the time where the early Google search case in the 2010s was being investigated in the US and dropped, Europe started a case against Google, which actually led to a decision and many years later in 2016, also on search. And so that kind of illustrates the difference in approach, where in the US, the case was dropped, and in Europe, it continued. Substantively speaking, the remedies that were imposed in the Google case have been criticized as being insufficient. And one could also compare the fact that, lobbying in the US was stronger against an investigation by the FTC. There were a lot more interests, tech interests that tried to get a seat at the table and tried to influence decision making by these agencies, of course, because we were dealing with an American tech company. And so there are some significant distinctions in how things have played out over the last 10, 15 years. At the moment, the biggest distinction is that the US is not able to pass any sectoral law on this problem, on the problem of how to regulate big tech from an antitrust perspective, whereas Europe, for various reasons that include the fact that it's a transnational body that's not fully democratic and representative, is actually able to pass very ambitious sectoral laws. And so we have the DMA, which entered into force in, I'm going to check my notes here, November 2022, and became applicable in May 2023. Gatekeepers have now been designated, and the DMA is actually going to basically start being applied from March this year. So we're going to see some interesting cases. The way that the DMA works is that it is a sort of regulatory framework Some people equate it to a utility-like framework. It designates certain companies as gatekeepers, and then it basically imposes some preemptive obligations on them. So thou shall not impede your competitors from interoperating with your, app store. Or thou shall not use your data advantage to benefit your search results and rankings compared to competitors, right? And things like that. So there are some preemptive restrictions, and the way that antitrust law works, on the other hand, is that antitrust law tends to be ex post and tends to come after the fact. So regulators identify conduct that they see as violating, be it the Sherman Act or Section 102 of the Treaty on the Functioning of the European Union in Europe, and they then bring a case against the company and impose remedies after the fact. So the problem with that approach is that it comes too late, particularly in a market like or in an ecosystem like the digital economy, which evolves very quickly. And so that's why we need to think and act ex ante in a preemptive way. The reason why, and I'm just going to close, the reason why I think the two approaches are not as different as we tend to think of them is that antitrust does actually include a number of features that make it a preemptive field of law. So think of, preemptive merger control, which could block a merger before the fact. You also have a number of remedies that can be imposed, such as breakup remedies, divestments, which actually can lead to restructuring a market in a very preemptive, forward-looking way. And so in some way, I think of antitrust as a regulatory area of law, and this is very controversial. When I am in panels with antitrust law colleagues, they disagree fiercely with me about the fact that antitrust law is regulation, but I actually believe it is. And so it's just a kind of different approach to regulation that we have here.
All right, so I want to see if any participants have questions. Anybody? Yeah, could you say your name and what year you are, where you are?
Yeah, my name is Jeffrey. I'm actually a PhD student in computer science. And so I was interested a little in like the tension potentially between privacy, digital privacy, and antitrust. Like I understand the example of the Google purchase of DoubleClick harming privacy, but it also seems like remedies, like opening up access to competitors or making data more accessible to competitors could be like really bad for privacy. So I just wonder, like, do you see these things as potentially working together, or are they at odds with each other?
Okay, next time I'm going to give the microphone to the person who's asking the question, but I'm going to repeat it in case anybody wants to hear it online. The question was, there seems to be a tension between privacy and antitrust remedies, and that if antitrust remedies are opening up space for competition, that could be bad for privacy in some sense, because your privacy could be more easily violated through the sharing interoperability agreements or whatever remedies are imposed by antitrust. Is that right? Anybody want to take that?
So I think, privacy is not an uncontroversial term, right? So there are various ways to understand what privacy is about. And so I do think that there have been lots of arguments by academics in particular, saying that privacy and antitrust are at odds with each other, that, you need concentrated power because that is a bottleneck that regulators can actually oversee. And so the data practices of Google are easier to analyze and to address from a regulatory perspective than the practices of a variety of different ad tech players who might operate in very opaque and fraudulent ways. So that's the argument that is often made. The way I see it is I think they go hand in hand, and I think it's not too controversial to say that. I think you need to regulate the power of Google in order to have a fairer and more transparent ad tech ecosystem. So it's not enough to say, let's, decentralize, distribute power. You have to actually think about the two things at the same time. So you need to govern big tech in ways that open up the market, and that will lead to more transparency and more governability for the economy as a whole. And so that's also a way into the privacy problem. Yeah, so, you know, the example of ad tech is one example, but of course there are several other ways to look at the problem.
Other questions?
And the microphones do go.
They do, okay.
Yeah, so just make sure you speak up, sorry, or you can, I just.
Lena Khan's article
First,
outlines,
who you are.
my name is Miriam, I'm with 2L. And Lena Khan's article does outline specific ways that we could use antitrust law to prevent another Amazon from occurring. But I'm wondering what you think about the capacity for our current enforcement structure to actually make the big tech market that we have that is so concentrated less so, because it seems like all we can do is prevent it from getting worse at this point. But I'm wondering what your thoughts are.
Well, I think that's the point of the FTC's case against Amazon right now, is that they want to take on Amazon. They're not talking about, as far as I know, what the remedy is going to be in the event that they're successful. They're simply wanting to prove that Amazon is dominating a marketplace. So I think that the point of it is, will they be successful in that, in their in the suit that's now pending? And it could be a couple of years before we know. Now, the FTC chose in this instance to initiate a proceeding in a federal court, meaning that it's going to develop the record in a federal court, and it's going to rely upon the generalist judges of the federal judiciary to capture from the economic evidence and expert testimony they're getting the education necessary to make a proper decision. The FTC could have chosen to start an administrative proceeding in which it could, within its own process, develop more fully the law in this area. I would say that they're suffering from resource constraints. Also, there hasn't, frankly, what's the outcome of that administrative process? You then go into a circuit, and ultimately, in order to get anywhere, it has to, whatever your order is in the FTC has to be enforced in a circuit, meaning that the generalist judges who are being appointed now, if there's a sense that they're more conservative in their economic leanings, they're going to ultimately impact even that sort of development of law. I didn't mean to. Sorry.
So a couple additional thoughts and reactions. One is that looking, forward, which is not your question, which I'll get to, but looking forward, there have been efforts legislatively to broaden the authority, to expand the authority of the agencies to deal with the tech sector. So Lena Khan wrote the article, then she worked with the House Judiciary Subcommittee to write the 600-page report on the tech sector. And I was involved with her at that point. And subsequently, there was an effort that about 8 or 10 of us did to draft legislation. And this was submitted to Representative Cicilline's subcommittee, the House Judiciary Committee. Of the eventually 4 or 5 pieces of legislation, only the most innocuous one made it through Congress, which was the Antitrust Fee Modernization Act. And that's in some jeopardy too. But the others were efforts, much like the DMA, to set out what was meant by, gatekeepers in the language of the EU, to deal with particular practices like self-preferencing, to document what constituted, conflict of interest on the part of a platform, et cetera, et cetera. So these were tough pieces of legislation. A number of them had bipartisan support because the tech sector no longer is everybody's fan favorite in Congress. But they never really came to a vote for various procedural reasons and a lot of heavy lobbying by the tech sector. So that's looking forward. So the agencies are hamstrung by having to deal with these relatively new practices, at least in the expansive way that they're being used, using older standards, case law, certainly ancient legislation, but that's not really the problem. They just need more specific authority if that's the way to do it. So that may not be the way to do it. It may be that what's necessary is a regulatory authority, a outright regulatory authority, something that Elettra and I would agree is a regulatory authority to deal with these things in advance. So what do we deal with, all of the structures that we've seen? So views vary on this. Mine, which I've written about, is definitely an outlier, and that is we need to break some of these companies up. That we need to figure out what part of the business is a core business. That's theirs. You can exploit it, monetize it any which way you want, so long as you do not also build a system that prevents others from, in moving appropriately into potentially competitive parts of your territory. And we've seen how the resources of the tech companies and the acquisitions that they've made of closely related businesses have created these so-called kill zones where they've, the venture capital that used to support the development of a lot of software that would be potentially usable or acquired by the tech companies. VC has gotten less interested in these because these companies don't really get to fully exploit the potential of their own bright ideas before they are sabotaged or acquired by the tech sector. So, my view, I've written about this, is that we should think about what it is that is potentially separable. Amazon logistics is separate. It just is. And, why is Amazon an e-commerce business spending $10 billion to get NFL football on Amazon Prime? Really, what you start to think about that, you ask exactly what's going on. There are answers to that, but the whole point is that this is not part of the core business. And similarly with Apple and Google and Facebook and Microsoft too, to some degree. So these are the sort of questions that have led me and some others to say, time has come to think more, constructively about the possibility of deconcentrating these industries. It should have been done at the outset, but simply looking ahead, maybe this is your point, is not sufficient because we have this fait accompli. And the question is, are we prepared to live with it as it is?
I saw some, yeah.
So I'm Ben, a second year PhD student in economics. And I was wondering for any of the recent big tech cases, do you lean more on the side of the companies and not the government's case, but the opposite?
So
What was the last part of that question?
There we are. So for the recent big tech cases, are there any of them in which you're more on the side of the company rather than the government's case?
Honestly, I don't know what the outcome is going to be in any of these cases, and I haven't taken a side, but I will say that there are the Amazon case, the FTC's case against Amazon, I see having issues coming right out of the box. I mean, the judge is saying as he's granting the motion to dismiss that I'm not expressing as I'm saying that you've plausibly stated a claim under the antitrust laws. I'm not stating that you have any chance of success. That's fairly unusual for a court to say in the motion papers. I'm granting you the ability to continue to pursue this, but good luck with that, sort of. And why would that be true? It's because these are, if we think about some of what would be the goals of antitrust, there's one school of thought, and I think a number of people fall into this school of thought, that we're talking about the operation of markets. We're not talking about achieving broader societal goals. If you want to change inequality, change the tax laws. Antitrust doesn't really fit that. If you want to make broader opportunities available in the perspective from the antitrust laws is that you have to have, from the antitrust practitioners, you have to have a case in which you can show that there's a violation of the antitrust laws right now. The fact that a company is successful and has got great scale and is huge might be the result of having created a better mousetrap. If you take the approach that we want to be clearer on who emerges from these contests, you're basically buying onto a regulatory approach. A regulatory approach is not going to be popular with most, I'm going to say most economists, but I could be, I'm not an economist. I would say definitely it's not going to be popular with most lawyers.
I'll just add that I'm not an economist and I'm not an antitrust lawyer. But it seems kind of obvious to me that antitrust is regulation. Seems like there isn't really another view, and how you set up the market is a form of regulation, but I'll leave that for another time. Yeah,
I have a question regarding, I'm Rachel, I'm a second year CS and philosophy. I had a question on how antitrust law might tackle or reckon with generative AI. So all these big companies, they have like the wealth of architecture and like sheer computational power that a lot of startups can't compete on. And in fact, they use the architecture that Meta, Amazon provide for them. So in that sense, like, is that a problem for antitrust, or what is that?
So I think, everyone's thinking about generative AI. Rachel, Rachel was my student last semester. So I think everyone's talking about generative AI, and as you know, the Biden administration issued an executive order where they outline a number of different fronts of action, which include a diverse set of tools and possibilities that go from government investment in startups, government investment in semiconductors, chips, and kind of inputs into the AI pipeline, to investing in crypto tools or allowing academics to develop crypto tools that will protect users from privacy harms, right? And those seem to be very, from a philosophical normative perspective, a lot of these seem to be at odds with one another. And I think one of the most promising fronts of action is what the FTC is doing right now, and the question of standardization. And what the FTC is doing right now is they're starting to think about the problem of incumbent power in these markets, and they're trying to investigate that incumbent power in a variety of ways. So they've issued a number of press releases. They have the beginning of an investigation into partnerships, where they're investigating Google, Amazon, and Microsoft, and their interests in Anthropic and OpenAI, and how these kind of interest partnerships might lead to advantages in the future AI markets that are emerging. And so that's one approach that the FTC is taking, which I think might combine an antitrust and a consumer protection perspective. So we should add, for those who are not lawyers, that the FTC, the Federal Trade Commission, has a double mandate. It looks at both antitrust and consumer protection. And there is a question of how antitrust and consumer protection kind of overlap with one another, particularly in these new markets. And generally, I think it's really important to scrutinize these partnerships, because they are not structured as traditional mergers. There is no traditional acquisition of shares, or if there is an acquisition of shares, it's often a minority acquisition of shares. And yet, the possible control that tech companies will have over the future of those new businesses is very significant. The other thing to add is, I think there is an ancillary problem, which is, I think, connected to antitrust, but perhaps slightly distinct, which is the question of why, how do startup entrepreneurs think, and how do they emerge? And very often we have in this space entrepreneurs that really want to be acquired by big tech, right? And they start their business with the idea that success is being acquired by Amazon, Google, or Facebook, or Microsoft. And so within that landscape, how do we enable the possibility of competition, of diversity in the market, of innovation, if everything will fall into the hands of existing incumbents? I think that's a huge problem. And so that's something that I think antitrust regulators are trying to adapt their rules for. But it's certainly, a question mark right now.
I think we are out of time. So I want to encourage you, if you have further questions, to follow up with our speakers. Thank you all for coming, and I want to give a round of applause for our panelists today. So thank you. And please keep an eye on the CLIck calendar. That's the Center for Law, Information and Creativity. Yeah, right. We have a number of events throughout the year, and we hope to see you at those in the future. Thank you. Oh, yep.
I'll just make a quick announcement that our next event is on April 2nd. We are inviting Michael Veal. If any of you have heard of Michael Veal, he's a superstar based at UCL in the UK, and he will be talking about AI supply chains. So we hope to have you, and we're going to make sure that we publicize the event, but please be in touch if you want to be kept in the loop.
Also, superstar, we use that term very loosely, right? So it's not a real superstar. It's like a law superstar. But we may, in fact, next year have a real superstar coming in. So stay tuned.